Just not. Oh, there's a new grant post on me. Oh, excellent. Because we're here anyway. So let's go for it. Let's see what he has to say. He's just a law student, though. I mean, I don't know. Is he first year, second year? Do we know? Hello, attorney. I spelled my name wrong. If you publish those court documents as a threat to Lindsay, I will not stop until I get your law license. Publish what? Threat to Lindsay who? Why would I publish anything that has to do with a case that I'm not even covering, Grant Smith Ellis? Those documents are protected by court order. You have ethical obligations, counsel. Really? I think, Grant, what you need to do is to go back to torts class and learn about the intentional tort of defamation. I just went over it just now. So you might want to take down your little video where you accuse me of having an affair with Alan Jackson and going to Cancun with him. So, there's that. Good luck with that, dude. Good luck with that. You want to come for me? Go right ahead. What are you're sending me a warning on what I'm allowed to do and not do as an attorney? Trust me when I tell you that I am perfectly aware of my ethical obligations, unlike you.
Welcome to the Young Jerks. We're starting where we ended last night, supporting Melanie Little, attorney Melanie Little. She went off against these trolls, these malicious, libelous, defamatory Grant Smith Ellis and some other people, and it hasn't stopped. And some new allegations, like crazy stuff that they're posting, going against different people that we're going to talk about tonight, and even another attorney. These people look like they're looking to get sued, like they're making up obviously false statements about people who are professionals, who are attorneys, like the worst people you want to try to defame. We've got a special guest. We've got two special guests. We got our friend Mazza Media. What's up, Mazza?
Good evening, Mike. Thank you for having me back.
And we have the very special guest, criminal defense attorney returning. He's a former assistant DA, district attorney from the Manhattan office in New York City. He's now a criminal defense attorney. Bederow Law is his website, his Twitter. Take a look at him. Welcome back, Mark.
Thanks for having me. Glad to be here.
Oh, wicked excited to have you tonight. It's crazy the amount of stuff that we have to cover, right?
You could probably go on for hours, days, weeks with this stuff.
And I have a little drive of some different screenshots we're going to show tonight, but this one I wanted to start with. You know who these folks are, right? Mazza Media?
Oh, I do. Karen Reed's parents and brother.
Karen Reed's, yes. This was Kelly Reed who posted this photo. I think that's Kelly Reed. Is that the mom or is that Kelly Reed? I'm not even sure, actually. I should have read that.
No, Kelly Reed's her cousin. That's,
yes. Yeah, Kelly Reed is the cousin. I'm wondering if that's her actually in the back with Karen, or is that the mom? I'm not sure.
I cannot tell. Maybe. Possible.
Yes, but this is the family of Karen Reed, which they've definitely suffered, and they've had a lot of bullshit come their way. So I also wanted to support them tonight because we're going to be showing some stuff I think that is completely liable against them, and showing just the amount of victims from some of these people out there that are just off the wall. So I wanted to give them support, the family of Karen Reed.
Great people. They've stayed strong through this whole thing. Not only strong, but confident, poised, and positive. And they're just, these people are handling this about as well as anybody could on the planet. And you have to absolutely appreciate that, which we all do. Great family.
And they are saying it is her mom. Okay. So I think Kelly Reed took the photo. She's the one who posted. The cousin Kelly Reed was the one who posted the photo. I wasn't sure.
It's Janet Reed, her mother. Yep.
Excellent. So we got that all straightened out. Help from the audience, which I love.
Yeah, she looks a lot like her mother, quite a bit. It's incredible, impeccable. I mean, if you had told me that they were siblings, I'd believe it. They look that much alike. It's incredible.
Absolutely. So we've got a lot to cover tonight. It's let's get to some of these slides. Just oh, this woman.
Oh, I needed a warning on that, Mike. I needed a warning on that. Oh, geez.
Attorney Bederow, you've been going at this Wendy Murphy, attorney Wendy Murphy, I guess. Is she still an attorney? She's on Court TV. We have a poll about her tonight. Should Court TV ban her from Court TV?
You asking me?
Yeah, what do you think? What do you think about that poll
Hey, look,
question?
they're a private business. They can do what they want, but just as a matter of common sense and having credibility, I don't know why you would have Wendy Murphy of any number of qualified attorneys that you could have speak about criminal issues, this particular case, but having a lawyer who, first and foremost, as we talked about the other night, is a Duke lacrosse truther. I mean, without more, that's just absurd. That's one of the worst prosecutorial misconduct scandals of all time. As we all know, the district attorney himself went to jail. And, you know, in Wendy world, that's no big deal. He was doing the right thing because these boys are probably rapists and probably were abused themselves and all that other nonsense. If that's not bad enough, she's been sanctioned twice, at least twice, we should say, in two different federal district courts under Rule 11 of the Federal Rules of Criminal Procedure, which any lawyer who practices in federal court, which I guess Wendy doesn't or shouldn't, knows that's the one thing you're always thinking about. Don't violate this. This can hurt me. It can call my license into question. I can be sanctioned. There are ethical problems, all kinds of issues that could arise. And in doing this 25 years, I don't know if I know any lawyer who's ever been sanctioned under Rule 11 personally. I sure as hell don't know someone who's been sanctioned twice, which she has. And the irony in all of this is what she has been sanctioned for is exactly the kind of stuff that, you know, I've been critical of her online when I learned about who she was in the last week, which is, you know, kids cover your ears. She's just full of shit about virtually everything. She files frivolous lawsuits. She's been accused of misrepresenting, making false claims, making bad faith arguments, misrepresentations. The list goes on. And to be sanctioned twice for that and to be a Duke lacrosse truther, I don't know how any credible organization seeking out lawyers would want to have her on TV. All she does is have a law degree. She poses as an expert when in fact she's just exploiting and leveraging her law degree to pose as an expert and just make absurd legal analysis. And anyone who disagrees with her, ironically, is an idiot, a moron, just, you know, someone who should be sanctioned. All of these things that she said in the past few weeks, which she has literally been accused of. And as you can see in what you're putting on the screen now, that's from a federal case in West Virginia from maybe 10 years ago, a little more, where the judge just takes her to the woodshed. When a judge is making a written opinion about you, saying that you're misrepresenting, you're distorting, that's not what you want as a lawyer. And it goes not just filing frivolous litigation. If you look at this highlighted portion that you've just put up there, she couldn't even name the court properly on 2 occasions. And I think, you know, so it's not just being unethical, filing frivolous litigation. There is a base level of competence here, which she clearly, the hurdle she couldn't clear that, you know, your third grader could. In other words, you file a lawsuit, you know the court you're in. When you file documents, you might want to actually call the court by what it's known. And on top of everything else, she couldn't do that. So should she be on Court TV? That's for them to say. But I will say this, as journalists, they ought to present the full picture. And the full picture is when she wants to go off and go into crazy land, talking about all kinds of wackadoo theories that have no basis in evidence, no basis in fact, and are just her speculation and her anger or jealousy over Karen Reed's competent attorneys who she's criticized repeatedly. If they're going to let her spew her nonsense, they ought to at least point out to the public that she is controversial. She has supported the Duke lacrosse accuser, who, as you know, is in prison for murder, ironically, and all of these other things. You ought to know who you're dealing with. I mean, look at this post you've just put up. She's calling the people who support Karen Reed and her lawyers maggots. Okay, so Court TV, wake up, take a big sip of coffee, open your eyes, and see what's going on here. Why would you want a clown with a law degree on TV analyzing? There's a million lawyers out there who can talk about this. This is not the one.
100. What do you think, Mazza?
Yeah, it's just her and her son right now, in my particular opinion, and I think it's shared by just about, well, everyone, is this is point, this is the point now where it's the point of no return, where it's basically, look, this thing's going to trial. They are so desperate right now. You just see it on the whole other side. Everyone that's not on the Free Karen Reed movement, not on the Turtle Boy side, are just losing their mind, especially Grant right now. He's just been throwing everything at the wall to see what sticks. It's just been total chaos. And her theory here, and I read this a few hours ago, and I just about I was floored by it. It was ridiculous. She actually made a theory several months ago. I think it was on Surviving the Survivor, where she claimed that the marks on the arm had actually come from the plow driver himself, that a plow had come by and swept them up and dragged them a certain amount of feet. And it's just, she comes up with all these theories that she's the one that's saying that our theories of why Karen Reed is innocent are outrageous. But then she turns around and comes up with these scenarios herself that are about as outrageous as you can possibly get. I mean,
also,
ahead, Mark,
she's a lawyer. Okay, she has a law degree. She's a former prosecutor. You'd expect to hold her to a high standard. She should understand how a trial works, how burdens of proof work, how evidence works. And instead, she's flipped it all on her head and says basically that the courage is obligated and should find that we start out that Karen Reed is guilty in the court of public opinion and in the public. Again, whatever the hell any of this means. I mean, the idea that she's teaching law students this nonsense is frightening. But she speculates and speculates. She's just throwing shit out there. No clue what she's saying. I believe she's guilty, so I'm just going to throw this theory out. I'll change it to this. This is just ridiculous. But for people who don't know who she is, she's a lawyer. I'm a former prosecutor. I'm a law professor. It may sound intelligent that if you don't know any better, you defer by nature to somebody who purports to be an expert. And then you just see this nonsense. And if you look at this tweet, she's stating this as if it's certifiable fact, as if there's evidence to support this. I mean, this is just dumber than dumb. I'm sure that the DA's theory, whatever that theory is, which I will get to later, they wouldn't agree with this. The defense obviously is not going to agree with this, but for an attorney to just throw this mud out there and with a straight face, there was a word we used to use where we would call lawyers who didn't care about their credibility and who would just keep coming no matter what. We used to just call them zombie lawyers. Okay. And Wendy Murphy is the poster child of that. And what I mean by that is when you're a lawyer and you just keep coming, no matter how hard you get hit, your credibility gets hit, and you just don't care, you'll just keep coming and nothing knocks you down. It's like a zombie in these movies. They just keep coming. And when you're a lawyer, credibility is all you have. That's your number one asset. Everything flows from that. And when you have someone who, you get slapped in federal court the first time, you get called as someone who distorts, misrepresents, files frivolous litigation, doesn't know what the hell you're talking about. The idea of publicizing that in an opinion and sanctioning you is correct your behavior. Stop doing this. What does she do? She does it again. And she's still coming. Her credibility means nothing to her. The Duke lacrosse thing. I mean, who's ever heard of anything so stupid as defending the integrity of the prosecutor and the allegations in that case? She'll still keep coming. In this case, I mean, what turned me on to seeing who she even was one of these tweets from a couple of weeks ago where she basically said, made a mockery of Karen Reed's right to due process and her right to not testify on her own behalf. And that means because she knows she's guilty, her lawyers know she's guilty, and this and that. And if you're a lawyer who does this for a living, all it's telling you is that Wendy Murphy obviously doesn't try cases. She doesn't know how to represent clients. She doesn't know how the practice of law works, because at a trial, and this is important, the prosecution has the burden of proof on everything. And the defense does not need to establish that the defendant is innocent. So it is not an exercise, as much as everybody always wants to see it. And there's certainly a lot of evidence to suggest that Karen Read is actually innocent. But that's not the issue at the trial. The issue is reasonable doubt. And if the prosecution's case is flailing, it's weak, and at the end of their case, they don't have much, and the defense has other evidence that they can offer that doesn't require that the client testify, then there isn't a single competent lawyer who is going to call their client to testify just to make everyone happy because, Wendy Murphy in Wendy world says, well, if she doesn't, you should all assume she's guilty. In fact, a judge will instruct the jury at the beginning of the trial and at the end of the trial, and as I'm sure she did during jury selection, you are not to draw any inference whatsoever if, in this case, the defendant does not testify, because she has a constitutional absolute right not to. The bottom line is Wendy Murphy should be ignored. She is a joke of an attorney. Her analysis is off base, and she has a documented track record of dishonesty, dissembling, misleading, acting frivolous, not even knowing what court she's talking to. She should be ignored.
We have a poll update. We asked, should Wendy Murphy be banned from should Court TV ban Wendy Murphy? Should they ban her? Should they not bring her back on? It started out at 91% said yes, Court TV should should not allow Wendy Murphy on their network. And now it's 92%. It's moving up. If
they want to have, alternative voices, I understand it makes for good TV. I mean, you might want to have somebody say, well, I think the prosecution case is this, the defense case is that. But at the end of the day, when you're an attorney, you have to have a soul. You have to have a compass and analyze it in a fair way, in that your skills leads you to analyze evidence. And when they ask you, what do you believe of the evidence? If you do have a soul, if you do have any credibility as a lawyer, you call it as you see it. And if there's a good faith basis to think somebody, has a problem with the evidence and maybe the prosecution has a strong case, there are plenty of lawyers who could probably articulate at least a reasonable basis for that belief, whether we agree or disagree, and have an intelligent conversation. I would suggest to you that having an intelligent conversation with Wendy Murphy is impossible, because when you call her out for her nonsense and stupidity, she's going to call you an idiot. She's going to call you a moron. She'll call you a maggot. She'll say that you should be sanctioned. She should just be shunned and ignored. And if Court TV wants her on, people should know what they're getting. That's all. And that's a business decision for them. If they find that credible, God bless them.
Excellent. We want to thank John Barron, 1921, who just gave us a super chat. I think we got a super chat. A happy belated birthday, Mikey says. Great show tonight. I'm looking forward to F. Lee Bederow being the exclusive legal analyst of the Young Jerks for the Karen Read trial. Thank you so much for the donation, and thank you to our guests too. And also Peter A became a new member on there. Thank you so much, everyone, for all the birthday wishes and all the presents too. You guys have been amazing. I had the best birthday ever with all of you last night, and this is going to be a great show tonight. We're already getting right into it about Wendy Murphy. Other stuff has been going on with her son at the same time, Grant Smith Ellis, who is just all the things you said about Wendy all apply to Grant, of course. And
I actually feel really bad for this guy. I mean, I've been watching what's been going on the couple of days. I understand from people tell me he's a law student. I know he calls himself a journalist. That's ridiculous. Nothing he does falls within the ethics of journalism or anything close to that. I understand he's Wendy's son, which, obviously could lend itself to, certain jokes or whatnot based on some of the things he said. But to constantly accuse everyone of violating people's rights and using big legal words that he's getting somewhere. I feel like somebody who cares for him off the internet for an hour and go on a bike ride or do something. He's not making any sense. And, somebody, you're putting up a tweet now from Mark Randazza, who's, a well-regarded First Amendment lawyer who did what First Amendment lawyers do. They fight for the rights of the public to have access. And it didn't work. Okay, fine. That's what lawyers do. You fight. And if you don't fight and ever take on tough cases and tough situations, sometimes you're going to lose. That's how it works. And yesterday, this guy Grant, who, again, it's important, he calls himself a journalist. Any journalist ought to be in love with the First Amendment more than anyone else in America. Okay, access, freedom of the press, access, all of that. And there he was yesterday mocking Randazza for losing when he wants to be a journalist and misses the point that what a lawyer like Mark Randazza is doing is fighting for people like Grant, no matter how odious they may or may not be, to have rights. And what happens? He criticizes him. And then today he threatens to sue him because he was asking a question about somebody else who might have said something or made a joke about something that person was alleging that Grant did. I don't care or know what the specifics are, but then he turns his venom to the lawyer. And this is just, somebody should intervene and just pull him away from the computer.
I'd love to know where he's going to get all this money to file all these lawsuits that he's claiming he's going to do.
Part of some of it too, I don't mean to cut you off, guys, but some of this that was going on last night, he was threatening to sue someone who he believed was this attorney Melanie Little that you started with tonight. And he constantly was accusing this individual of being Melanie Little, and this is just going on, and he's threatening to sue her unless she deletes her account. It does things. And I actually jumped in, and I know he's a student and whatnot, and said, you're basically extorting her, okay? Under the extortion laws of certainly, I'm sure Massachusetts actually looked it up out of curiosity, and certainly New York. If you threaten to file, criminal charges or take legal action or deprive somebody of something that they have a right to do by coercing them, that I will do that unless you do this, that's attempted extortion.
And over state lines is a federal crime too, on top of it, right?
It could be. I mean, realistically, federal prosecutors, one would hope, have better things to do than that, such as, I don't know, investigate possible corruption in state prosecutors' offices in connection with high-profile murder cases and little things of that nature. But it's unfortunate because there are so many sideshows and circus acts that have become associated with what is, a real serious case. And I mean, look, a man lost his life, and that's serious. And people, have to respect that, be concerned about it. But on the same token, there is a woman who's been indicted where a lot of people believe is not guilty. Many people believe as well that she's actually innocent, and she has certainly asserted her right to trial and has, said, I am innocent, and has every right to do that, and has really competent lawyers who are zealously advocating on her behalf. It would be nice if, people would respect her right to a fair trial, let that play out, and what happens, happens. Now, when that does play out, I have no doubt, assuming that, the jury was picked fairly, that I don't see any way that Karen Reed will get convicted of anything. But putting that aside, they have a right, to charge her if they have any evidence, which I don't think they have much, and she has a right to defend herself. But how this has morphed into Wendy Murphy's son threatening to sue everyone and acting as an advocate, on an unrelated thing involving Aidan Kearney and all of that. I mean, this is just Looney Tunes. And
Andy Kaufman stuff right there. I'll sue you, Mr. Lawler.
It's crazy. And it's like, it goes on and on. I mean, he's going after attorneys like Mark Randazza, who I just want to thank. He's obviously watching, listening, because he just became a member of the Young Jerk. So, and Mark Randazza, he's just doing his job, and now he's getting attacked like that and has to respond. And told Grant, you got to take your shit down. And now another attorney, Melanie Little, has also said the same things to Grant. And he's escalating. It's getting worse and worse. It's like, where does this end? What do you think this ends?
He just tweeted to her again moments ago, 11 minutes ago. He just put out a tweet 11 minutes ago about something about going to Georgia to visit her daughter in early April of this particular month. And he's going after this Haley Welbrecht as well. And he's claiming that they're the same person or something.
It's, normally.
Which they're not. I know for a fact they're not the same person.
Normally, I would say, when you're in class, walk down the hall and talk to your mother, the legal expert in the law school hallway. But in this case, I probably wouldn't do that, although she's apparently very familiar with making outrageous claims unsupported by evidence. But all kidding aside, somebody should just calm this guy down and it's sad. I'm telling you, watching this is just like a train wreck where you can see as it's panning out, the train is coming down and the cliff is here, and it's going to take a while to get there. We're not quite there, but that's the only way it's going to go. And it's, and some people are so venomous towards making sure that Karen Reed must be guilty and we're going to enjoy this when she's convicted, that anybody who's willing to take that view, no matter how incredible they may be, such as, mother or son, they just support them. And all they do at the same time is sacrifice their credibility. Again, if you want to wave the flag that you believe this woman who's pled not guilty is innocent, then good for you. You have a right to do that. But certainly you can find somebody better to advance your cause than Wendy Murphy or Grant. My God.
Here's a perfect example, too, of how Grant operates a lot. This is a troll account that's posted some of the most problematic posts about all of this crap. Post this ridiculous thing, not backed up by anything. And then Grant runs it like it's a real news item, like that's been vetted, like it's real. And it goes after Karen Reed's brother, who has nothing to do with anything. And it just treats it like it's factual.
Well, but that's what Wendy does in a different way. She tweets this stuff about, I made a joke about this earlier. All she was missing in her wackadoo tweet from a few hours ago was, putting somebody in the grassy knoll. It's lunacy. They should just be ignored. They really, and the people, what they should focus on is there's a trial that's going to start. Do they have a case? What is the evidence? What are the issues? And what's going to happen? And make sure that this woman gets a fair trial. And if she does, I have every expectation she's going to walk out of there.
Absolutely. You got anything on that, Mazza?
We got Melanie Little in the comments right here. She said, for the record, I have nothing to do with the sock puppet account. He is unhinged and is now threatening my family. I have no idea who this Haley is, and this is now bordering on criminal.
It is. As I said yesterday, and again, I don't know literally what he was saying directly to Melanie, because I know he was attacking somebody else, screaming that you are Melanie. I know it. And this person was telling him, no, I'm not. And he said, you are. And, again, 2 + 2 is 5. I say so. You're Melanie. So, and when I said last night, he was essentially coming real close, if not past, extorting that person. Now, he's also clearly, coming close to the line or past harassment. And it does get trickier, theoretically, if it does occur over a wire, which a computer obviously is. And if, I don't know where Melanie is, and I'll assume Grant's in Massachusetts, but if it does involve different jurisdictions, then, theoretically that could also become a federal thing. But I don't think it would be. That is rather, the way federal prosecutors work. That's not the kind of thing that they would necessarily do. But yeah, there's no question that at this point, it's a form of harassment and potentially extortion, attempted extortion.
Crazy. No woman should be going at like dealing with this crap. Like this happens all the time too. We've seen it over and over. There's a pattern here, and it's really disgusting.
Yeah. And, again, I don't know who he's associated with or not, but, and I'm going to assume that even these prosecutors want nothing to do with him, but to the extent that, he's their number one fan, they ought to be trying to tell him, just shut up. You're not helping. You're making this worse. You're making us look worse. And all you're doing is making more people believe, before any evidence has been presented in court, that this woman is being railroaded.
It's funny you say that, because I hope I should have asked permission, but I'm gonna assume this person's gonna be okay with me saying this. But I know a Free Karen Reed supporter who's been paying Grant gas money to show up at the protest because he thinks that Grant's presence actually helps Karen Reed. That's how insane Grant is. So I think all his supporters should consider that Free Karen Reed people like Grant being there now. We realize that he actually does help the defense with his craziness. Would you agree with that, attorney?
Well, yeah. I mean, again, I'm new to a lot of this, especially the sideshow part of this, but I understand a week or two ago, and correct me if I'm wrong, but wasn't he running and approaching Karen Reed, who, again, is on trial for her life, and he's running around asking her if she's having affairs with people involved in the case? I mean, that's just...
Yeah, he's suggested Alan Jackson and her having an affair. He even alluded to Melanie Little and Alan Jack. He's just making up all these random things like he's writing a soap opera. It's ridiculous.
It's embarrassing. And again, putting aside the mother-son joke component of this, mom is a lawyer, okay? Putting aside all her checkered history herself, is there nothing she can do as a law professor, as a legal expert, and perhaps most importantly, as a mother, and say, stop doing this? You're clowning yourself. You're potentially creating legal problems for yourself. And of course, the more each one of them goes off the rails, they make the other one look equally as bad. And it's a sideshow. It really is. And they really both should just go away.
Yeah, it's exactly well said, Mark. I'm tired of this sideshow act. It's taking away from the case. They're making it about themselves, whether it's on television or in person, and everyone's just sick of seeing Karen Reed heckled by this guy, to the point where the Massachusetts State Police actually went after Grant this past week. They didn't realize he actually had press credentials, and they said, "Hey, stop agitating, knock it off."
I don't know how long he'll have he's not acting like a journalist. I mean, he's harassing. And I even saw something late last week that there was a journalist, I forget what entity, maybe like the Fall River something.
Fall River Reporter.
Yes.
What's her name?
Jessica Machado.
Who I think also was saying that, look, she's a reporter. She's there in the same press pool. And I think she was saying something along the lines of, he's harassing me or bothering me or something. And it's just, look, he appears to be a gadfly and just a nuisance. And it's hard to ignore that kind of stuff. But really, everybody should, both of them, and just, watch the trial. And, we can talk about that today, every other day. And
definitely, we're going to play some video from the last court hearing too. I want to note this one though, because now there's parody accounts of Grant Smith Ellis, and they're hilarious. But people are actually
the First Amendment a great thing, Grant. I mean, here you go. You've parodied yourself.
Yeah, and people are falling. They're being fooled by the parodies. So that shows you like how wild Grant is, because people will believe anything now. Like this is one of them. People think this is really Grant because of how wild he is. This is a parody of.
This is such a clown show that somebody put up something today, which they, as part of this Wendy Murphy stuff, which they professed was a drawing that she made outlining this, wackadoo tweet she put out today about the glass and this, and how then he probably scraped his arm doing this and that. And I have to tell you, usually I have a pretty good eye for when somebody's kidding or not. I still don't know whether this person is making a joke or being serious because, you know, in Wendy world, up is down, down is up, left is right, right is left. Who the hell knows? What was that? Where somebody just said something about he accused somebody of being an informant? That's
Yeah,
dirty business.
he did that. He did that to Aiden.
Yeah.
When Aiden went to jail, prison, whatever you call it, when he was held for 60 days, Grant went around and said that he was an FBI informant working against the like Aryan Nation type people.
That is the kind of thing that can get somebody killed
with no evidence, of course.
That is disgusting, and you know, that's his Duke lacrosse, really. So
yeah.
that if that's true,
it's very true.
That is just disgusting beyond belief.
And he's done it on video too. Like he's you know asked that, you know, just like he stalks Karen Reed, he's been stalking Aiden with made up shit too all the time.
Yeah.
So he is a very dangerous person. I know this for a fact with dealing with this kid. There's nothing that would surprise me about him. Let's go to the court, because this is there's a lot that happened in court this week, but this is like one of the bigger ones that I just want to bring up.
Sure.
And of course, you know, we're gonna get to Yannetti and Jackson, but the first one, the first clip, is Eliza Little, who's pretty. Yeah, we're gonna get Yannetti up there, but it's Eliza Little against Lally, and I think the clip. The reason why I want to play this one first is I think that it was important because it's about Michael Proctor. It's about the corruption of the police, and I think we're gonna see some debates about what gets allowed, and I want to have the attorney's viewpoint on all of this. So we're going to get into the videos now. Let's put this one up right now.
Commonwealth's motion to prohibit reference to any pending internal affairs investigations or unfounded allegations. And I did just, I don't know why, I know you filed it previously, Ms. Little, but I just today had the opportunity to read your supplemental memo in opposition. Okay, so all right, so this is twofold. So I'll hear the Commonwealth regarding Trooper Proctor and also regarding Sergeant Lang.
Sure. Your Honor, with regard to, I think the recent sort of progeny of cases between McFarland and Graham are sort of entirely instructive, I would submit, as far as this particular area is concerned. So when it comes to Sergeant Lank, you're talking about a civil case with no judgment. There was no finding. There was no trial. So I think Graham and McFarland are pretty clear that is not conduct that can be used in a criminal case to impeach a witness.
Why can't it be used regarding, I think what separates this in some respects from those cases, even though there's no finding, is just like the pure bias part of it, right? If there's bias in favor of the Alberts, which is what the defendants say their defense is among the possible third-party culprits, why can't they cross-examine on that?
Well, the information that I've seen, I don't think specifically lends to a defense of the Alberts. I think if it lends to anything, it lends to Sergeant Lank being involved in some sort of altercation himself, and whatever extent there's any veracity to whatever is alleged by the other parties to have occurred. Firstly. Secondly, I don't even believe, again, I think we're going to, one Albert equals the entire Albert family kind of thing. And I don't think that any of the Alberts that they point to, or at least that Mr. Yannetti got up and spoke about being potential third-party culprit targets, were even present, involved, or had anything to do with this prior incident. So whether or not Sergeant Lake knows or was 20 some odd years ago friendly with one member of the Albert family, or even two, if they're not any people that were at the residents on Fairview Road that night that were present there in the morning when he arrived, pursuant to a call from a sergeant on scene to investigate, or anything of that like. I don't see how it's relevant to that form of questioning or impeachment, particularly where it's an unsustained finding and there's nothing concrete as to what transpired.
Okay, I guess my question was simply because something might not fit squarely in McFarland and Graham. If it's admissible for other purposes, then it can come in.
Right.
So who's arguing this part? We'll take these in two parts. So we'll do the Trooper Proctor part afterwards. But Ms. Little, I did say I'd give you the opportunity to argue those two cases, but if you want to.
We're going to stop it right there. What do you think about Adam Lally so far? His points.
Look, one thing you hate to do, and I know we have done this a little bit before, is try to be so critical of people in the profession and whatnot. But the bottom line is, this is the guy they've looked at and said, we're giving you the most high profile case that we're ever going to get in this county. You're going to get us to where we need to go and be the vessel to present the evidence, make the argument, and do whatever. And, I know this is only a 5-minute snippet, but man, his body language, his demeanor, everything about it just reeks of blah. And, he's staring at the table. It's a lot of word salad. He looks very nervous, which, to some extent is understandable. But, there's no confidence in what he's saying. There's no clarity based on the word salad. And I don't think there's much logic because lawyers understand, the one thing on cross-examination that is almost always permissible is to attempt to impeach a witness for actual or perceived bias. I mean, that's the most fundamental form of cross-examination, that you're, an argument that you are in favor of the other side or specifically against me, and to make an impression on a jury through, hopefully for that side, through asking questions and getting answers, to demonstrate the bias, which could therefore impact the witness's credibility in a bad way. And that, the argument is obvious. If somebody's biased for, against me, then you should consider that and whether you should credit their testimony. They have a motive or an interest. So if there is an allegation that these witnesses are friends with the Alberts or have a relationship, even if it's 20 years ago, she's right. The judge, that is. I mean, that you're allowed to do that. And when the DA says, well, it's unfounded, the answer is, if it's unfounded, the witness can deny it, and the judge will usually say that's the end of it. I'm not going to let you prove it with other evidence. I'm not going to let you call a witness and turn it into a mini trial, which in certain cases, if it was important enough or established, you might. But arguing that the defense should not be allowed to examine witnesses for bias, being, friends of the Alberts, which is a centerpiece of the defense. And I want to talk about that when we get in a little bit later, why that's a key point of this, most likely going to be reasonable doubt in this case. Of course, they're going to be allowed to argue that these witnesses, if they choose to do it, are biased, and the jury can determine it. And if the lawyers look like the defense look like they're flailing at straws and throwing up mud from 20 years ago, that doesn't make any sense, well, there's a risk in doing that. The jury might say, these people have nothing. Why are they doing that? But that is a decision the defense gets to make. And you see this all the time with prosecutors who are guilty of having tunnel vision. They want to do it their way all the time and make sure that they're not allowed to do anything, meaning the defense. They're going to be allowed to attempt to impeach witnesses for having a bias in favor of the investigators and the witnesses in this case. They're going to be allowed to do it.
So someone's mad at me. They said, saying a free Karen Reed supporter is paying Graham. Maybe I shouldn't have said that, but it's true. And I just because I think Grant needs a check. He needs to realize how crazy he is. Like, he's so bad that people have actually thought that maybe he's good for the free Karen Reed side. Like, that's how, I mean, I'm not making judgments on whether people should support him or not. I'm just telling truths, and other people are commenting on who it might be. I think there are multiple people actually doing that. So don't be mad at me. Sometimes maybe I'm too truthful. I'm not trying to start shit. What do you think, Mazza? Was I too truthful on that?
You backed it up by saying that the person basically gave him the money because essentially it would make the Karen Reed team look good by having him out there as a villain. So every good hero needs a villain, I guess, is the defense you can go off of with that.
Yeah. And I didn't tell him to do that.
Right.
I'm reporting, I just what was the other thing I wanted to get to on this?
On Lally?
Yeah, about Lally. So you have something to say, Mazza?
I do. He's not going to be able to captivate a jury. Someone in the comments said, I can't imagine being in the jury and having to listen to this guy for 45 minutes straight. Not only is he incompetent, and he seems like he's also bored, and he kind of just rattles things off like it's just another day at the office and he's just been bored with the job for 10 years already. He's not going to be able to captivate with a great, powerful presence the way David Yannetti and Alan Jackson and Elizabeth Little are in court. And it's just not going to captivate a jury. And regardless of whatever facts of the case that are here, that presentation alone is going to come off strong when you're a juror listening. Because people in the comments here are bored listening to Adam Lally, like someone else alluded to earlier. I can't imagine what a jury is.
It's actually a big deal, particularly in a case like this, which is as high charged as it is. And more importantly, look, it's a circumstantial case with no real evidence, and it's going to require a prosecutor to really fill a lot of holes, and they're lacking the evidence to do that, which is a whole nother issue, why they probably shouldn't have even indicted her in the first place. But that's probably a conversation for another day. But if they're going to do this, then you have to compel yourself and make the jury believe that I, as the prosecutor, I believe this and I have faith in this, and you can believe me because I'm going to tell it to you straight and do this. And this guy, again, I don't know him. I maybe he has skills that we're not seeing. I don't know. But if this is what it's going to be, given the state of the evidence and the manner of presentation, and given the skill of Karen Reed's attorneys, that's not good for the prosecution, because what's going to happen is the defense attorneys are going to get up there, and it's going to be obvious that they're going to look these jurors in the eyes. They're going to tell a story. They're going to present their theories. But most importantly, they're going to project confidence in what they're arguing, and they're going to make the jurors say, you know what? These guys actually believe what they're saying. They believe in the client. They believe what they're doing to her is wrong, and they're telling us why. And it's the kind of thing that tends to resonate with jurors. And if the prosecutor gives an opening statement and it's just some kind of schlubby nothing, and I'm going to read my notes and stare at the floor and sigh and just mumble word salad,
Yeah, right.
and don't even bother. Yeah.
Let me ask you about somebody else who comes up that I think the free Karen Reed needs to cut her some slack a little bit. And I think you might agree on this, Attorney Bederow. How's the judge doing? It feels like to me, the judge is reluctantly letting the defense do what they should be able to do. Is that correct? Am I right on that? Is this
based on what I've seen? This may be somewhat controversial for some of the people, but everyone is not the enemy here. Everyone is not part of some conspiracy to get people. And generally speaking, I think the judge has made rulings that are based in sense, logic, and law. I understand, they wanted to recuse her. I get it. I've made those motions, and there's always a concern, what happens. But, listening to that snippet you just played, that's fine. Yeah. Is she the most personable sounding judge? No. But, they're judges. They are what they are. They're supposed to be, the referee in this, and I don't have a problem with that. And, I know a couple of weeks ago, there was this big controversy, for example, over this, third party culprit defense. And Now, a lot of it gets distorted because of, morons like Wendy Murphy who run around and say what a huge win for the prosecution. They're not even going to be able to make a third party argument in their opening and this and that. And the reality is, my understanding of what she ruled was, well, I need to see where the evidence goes before I allow you to do that. Now, obviously, an opening statement is not evidence. And I think a concern of any judge would be if I let lawyers open up on some kind of theory that there's no evidence of. I don't want the jurors hearing it, potentially being prejudiced, confused. So she says, I'm going to reserve. Let's see where it goes. And if you make the argument, then I may very well allow it. That's not a bad ruling. That's the proper ruling. I'm sorry. The judge, look, you're never going to get all the rulings you want. I know there's some other issues people have with her, but I don't think that she is the problem here. And at the end of the day, the evidence that the defense needs to present that's going to most likely demonstrate that Karen Reed is not guilty will come out. The jury's going to hear it. And I just don't fathom how, and we can get to that again in a little bit, how the jurors, when they hear that evidence and they hear the lawyer's arguments, putting this all together, are going to say that, yeah, I believe beyond a reasonable doubt that she's guilty, as the other 11 people sitting next to me do. And to get 12 out of 12, I don't think that's going to be difficult.
Yeah, I don't either. Attorney Bederow, what do you think, just from Adam Lally speaking right now, about Trooper Proctor, who's under state police investigation, and this other guy, Michael Lank, who got sued, because of his actions? The town of Kenton got sued. He's a Kenton police officer for his actions. There was no finding in the case because it got settled. The town agreed to pay out the victims. Is that going to be allowed? Do you think that will actually be allowed?
It gets tricky because a lot of times, the argument is that the government will settle lawsuits without any admissions of guilt just to make people go away. You throw them a few dollars. And of course, they say, that he didn't admit to doing anything. But again, if it goes to his, credibility and there's enough evidence to allow it, a judge does have the discretion to basically, in New York anyway, to say, I'm going to allow this to a limit. But you can't, we're not going to turn this into a mini trial. Now, as far as, the guy that was sued 20 years ago, is that a little so far out that any of its what we would call probative value is substantially outweighed by its prejudicial impact? Maybe. Proctor is a different story. When it comes to him, they're going to come after this guy and they're going to hit him, and that is a centerpiece of their defense. And he is the poster child for the beginning of the alleged corruption in the case. And the fact that he is a friend of the Alberts and, poses with their kids, I think, on Facebook and whatnot, that's definitely fair game. His credibility means everything. And, this whole thing where, when he interviewed witnesses or other investigators like him interviewed witnesses in a murder case or a murder investigation or just the homicide, just somebody was dead. We're trying to figure out how. And they decided there's no need to take any notes, no need to record this. That's all going to come in because it doesn't matter what the DA is going to say. That's suspicious. Okay. There are no prior recorded statements of these witnesses. Why? We have an expression in New York, detectives in the New York City Police Department fill out a form called the DD-5. That's a detective's report. And there's a joke or an expression in the NYPD that if it's not in a 5, it didn't happen, meaning these are professional investigators and, you write it down. And it could be for any number of reasons. One, not just to memorialize a witness's statement in the event that they change it down the line, but what if the person who interviews them retires, dies, is incapacitated? How do we know what the record of what these people said? And that's just one component of it. Why didn't they ever go inside the house? Exactly. Where Officer O'Keefe was found? They never went in there, is my understanding. They never searched it. They never looked around. I mean, what that tells you as a defense attorney, and this is going to feed right into the defense theory, is because they had tunnel vision. Obviously, they didn't go in the house because it wasn't going to be them. It's going to be someone else.
Exactly.
And the argument the defense is going to make is that Karen Reed is the patsy. She's there. She's the perfect target here. She's breaking up with him anyway. So who cares? We can't have this fall on anyone. And when these initial investigators are examined about why they didn't take notes, how do you not even go in the house? And it turns out the house is sold shortly thereafter. And, they rip up the basement floor and close in the pool or whatever this stuff is. Look, does it prove anything? No. But is it suspicious? Yes. On top of any number of other things, including, and again, I don't want to jump the gun on this, but, this whole fiasco with finding the taillight a week later from a moving car that no one found a week before. I mean, that makes no sense.
And now that police chief is sick and he's not going to be able to testify. They're saying,
that's
how convenient.
Berkey.
Everybody's getting sick on that side now.
He's testifying. Okay.
Yeah. Will he do a Zoom from the hospital bed?
Short of dying. And you know what? If I'm the defense, hell, I would adjourn the trial and say, no, we want him in court, in the chair, under oath, because we have a lot of interesting questions to ask him. And, again, when you go to that theory of that they're going to present, you have the chief of police, right? Is that who that guy was? Literally?
Yes, he was. Okay. He was. Now he's not.
So
yes.
Nobody finds this taillight for a week, even though the crime scene is swept, and he sees it from a moving vehicle.
Mm-hmm.
He just happens to see it. And this is the same guy who I also understand at some point in the early stages called a reporter and said, you need to take a story down because that's a good guy you're going after.
Yeah.
That is
the Albert name out.
Let's not push that aside as a small thing. Okay. When we talk about actual bias, you have the chief of police who is telling a story, which is probably incredible and is a linchpin of the prosecution's case. It was the taillight. And then the evidence of his bias couldn't be any more obvious. I'm going to go to a reporter and say, I know you're just reporting the news, but you're going to hurt a good guy. He's going to get clobbered on that. So this guy, they'll save a chair for him. He's going to testify.
Yeah,
I hope
that's
so.
good to know. That's reassuring right there, because that's an important piece of this whole thing. Is the fact that he just drove down the street and happened to see it when the CPD and the state police both swept that crime scene, and whatever they found was whatever they found.
And Berkey is the fixer. I mean, he's the guy who's known everyone forever. That's what he's known for. He's the guy that everyone likes.
The other thing is, again, to go back to what we were talking about when we were talking about Wendy Murphy, is lawyers need to be credible. And in particular, the prosecution. I mean, you brought charges, you have the burden of proof. You need to look the jury in the eye, and you need to be consistent and credible. And so when they're going to present, presumably at some point, or have to deal with this, borderline ridiculous story of the chief saw a small taillight in a moving vehicle a week later that nobody else saw, and he just aha. Well, what about they seem to be claiming, based on some documents I read, that this is the DA, that they find it suspicious that when they were all looking for O'Keefe, that it was Karen Reed who knew exactly where he was, right? And only she knew. And the inference is because she left them there, lying there. Okay. So if it's seemingly ridiculous that she could independently just see a human being who is, 6 feet tall or whatever he was, lying there, that strikes them as a big deal. But the chief, who just happened to see a small taillight and then went to the press and said, don't do this to, he's a good guy. That's believable. I mean, that strikes me. And I think the way that the, defense will argue this as intellectually dishonest and not credible, and just another piece of what we believe is a frame job. And again, they don't have, and let me be very clear, they don't have to prove a conspiracy. They don't have to do any of this. But whether you believe that this is an absolute setup job or not, one thing is unavoidable, and this is going to bury the DA either way, which is the defense is going to argue, okay, in the worst case scenario, this is really disturbing. I mean, they did her dirty. That's the worst case argument that they could make, that this was a cover up that was hatched between, the people in the house and the local cops, and, something that rather, you might think you would see in the South in, the 1930s than Massachusetts in 2022. But, you don't have to believe that. But the problem the DA is going to have, that in the best case scenario, this investigation is pathetically incompetent. Okay.
Yes.
The not documenting what happened, not going into the house and looking around, not interviewing every possible witness. Okay. It's the tunnel vision, and the defense, they're going to say this. You may hear those exact words, tunnel vision, that this was all about Karen Reed from the beginning, and they did it backwards. Okay. They found their suspect, and now we're going to make the crime, the square peg in the round hole, rather than take it where the evidence leads us. And maybe, if they believed it led to her, that's what they do. But the problem is they didn't do anything that would even suggest that they were looking for anything. For example, the night this happened, why wouldn't you think that perhaps the most logical people to speak to would be the people that were in that house? Okay.
Yeah.
Why wouldn't you secure a crime scene? Okay. Right. Which I think somebody is actually saying right now. So kudos to them. That's absolutely correct. There is a dead man lying on the grass who, as it turns out, is a local resident and police officer. How did he get here? What are we looking for evidence? What are we doing? And they don't do any of this. They don't find the taillight that the chief finds later. Do they examine, I know it was snowing heavily and he was found later, and, perhaps the tire tracks would get covered up and this and that, but did they look around for other evidence? Why didn't they bang on doors? What did you see? What did you hear? Okay. There are these other issues. They're missing video. How the hell are they going to explain that? This library video? I mean, again, when you talk about the competence and fairness, where is this stuff? And again, they have the burden of proof. The defense doesn't have to do anything. They will, I'm sure. But they are going to clobber the DA on this. And you could find without more that this is such a shoddy investigation. It's so incompetent that how are you going to have confidence beyond a reasonable doubt that she must have done it because based on what? Because the medical examiner says that, maybe this caused it, which is a whole nother issue. I think the science is not in their favor either, which I'll get to in a little bit. But because we found a taillight that, according to the chief, which by the way, is that documented? Is there video of that? Exactly. How do we know? And, and I understand there is video. Okay. There is video that for all intents and purposes may show her car strike O'Keefe's car, which could have caused the minor thing that she had. Okay.
Correct.
Correct. So the chief finds this taillight. There are so many other problems with this though. I understand they're alleging that she, backed the car in at a high rate of speed and just, hit him. In the worst case scenario, I assume she could have been doing about 25 miles an hour on a driveway, which certainly I think would be enough to, kill someone. But given what they're describing, there are some common sense problems that jump out here. And again, burden of proof, DA, they have to get past all this. The defense doesn't, but they'll certainly suggest this. If she's driving on the driveway, how in the hell does Mr. O'Keefe land in the middle of the grass, however many feet away? Okay.
Yeah, that makes no sense.
Exactly.
Let me make it worse, because this is what lawyers do, and this is what these very accomplished lawyers are going to do. They marshal one fact with the next fact. Okay. If the DA is correct, and that did happen, and they say, well, it did happen, he did get launched and land on the grass because she hit him so hard, then the next problem they have is look at him. Okay.
Mm-hmm.
Imagine getting just trucked by a car at high speed and launched. Okay. Presumably, he's not hiding in the driveway, lying down, which would not have done that. He has to be some degree of standing up. Okay. And the point of impact on his body would be pretty traumatic in terms of fractures, damage, internal damage. And my understanding, based on what's been put out there, is there are not any real severe injuries to his midsection, his
Correct.
legs, his
Correct.
back. Okay, that in and of itself could be enough. Okay, when now you put the next fact to that.
Right.
The other problem is if the DA is right, then you're telling me with a straight face that the damage on her car is a fracture, a minor fracture in her taillight. Oh, by the way, that nobody saw for a week until, Chief Wiggum here, from The Simpsons found it,
I got that.
happened to see it, while he was driving by and says, look what I found. And oh, by the way, let me remind you, that's the same guy who said, don't you go after the Alberts or this one guy. He's a good guy. By the way, none of this has to be provable from the defense standpoint. These are doubts. Okay.
Right.
These are reasonable doubts. All right. And then the last thing in terms of the injuries and whatnot, which don't make much sense, is I know there's this issue with his arm. Well, actually his arm and his head. Let me there are a series, and I haven't seen any autopsy report. I've read hundreds, if not thousands in my life, but I understand I did see a picture that was posted online where there's a series of cuts that appear to be in is that his right arm? I'm trying to visualize the picture. But there's a series of almost like slice type cuts in his arm. Now, let's all agree to send Wendy Murphy to her room at the little kids' table and stay out of this, okay? We don't need her nonsense. It's not from a cocktail glass that he was holding that got shattered with the light and somehow miraculously sliced them in 5 lines. Let's put that to bed. So the question is, what is that going to come from? What are they arguing? What are they going to say? That because he got dragged? But he's on the grass. If he got dragged, he wouldn't be launched. It's got to be one or the other. I know this is gruesome to think about, but if you're going to end up in the grass from the driveway, if you've seen horrible accidents or heard about them where people get launched, you're not getting dragged. It's one or the other. Then they have a defense expert, clearly, who is saying, well, these are not inconsistent and could be dog bites.
Right.
And now again, the Wendy Murphys, the other sycophants for the DA and whatnot. Does the defense have to establish their dog bites? No. Are they able to establish their dog bites? No. How could anybody from their side know months later? But the key is that they're going to put a medical examiner, somebody who used to do this, testify for the prosecution. I think somewhere in California, I think if I'm not mistaken, is going to say that those injuries are consistent and could be. In other words, you can't exclude the possibility that those could be dog bites. And again, they don't have the burden of proof here. And you have to always think of it in that way. It's really the DA has to disprove all of this if they're going to have any chance of winning. And then you add the last piece again, as you marshal all of this. This is why the DA is, they're screwed here. I mean,
You think they're screwed?
yeah, they shouldn't. I mean, look what we're doing here. I don't know how you're going to get past all this. And no matter what they think, you have to get through, the reasonable doubt problem. There's just all of this evidence that goes on top of this, on top of that. And how are they going to say, we have an answer for all of that? None of this matters. Don't worry about it. And I had one last thing of this. I might have forgotten about it for a second, but something about the medical examiner. Oh, the back of his head.
Yes.
Yeah.
There is
The gash.
a large gash. Where is that coming from in the context of I got hit on a snowy driveway,
Right.
landed in the grass. I'm going to assume that because, these investigators, were so competent in handling this, that they might have taken a lot of pictures before they removed Mr. O'Keefe. And if there were any objects or anything located near him, they would have photographed them. Okay. How is he getting a large gash, a sideways gash, which appears to be some instrument that could either have a sharp edge or a blunt edge, but thin enough to slice in a thud-like way, hit him in the head? That's not a taillight. That's not a taillight.
Right.
That's not the snow. It's not the grass.
Nope.
Now, the defense is going to say, yeah, it's him getting beat up by someone in the house. And again, how are they going to get past this? Why is a medical examiner saying we don't even know the manner of death? That's crazy, by the way. Whatever the admissibility ruling on that was, the idea, we don't know what the manner of death was, but we know it's not from a fight.
That's right.
Right.
Okay. If you're looking for red flags and conspiracies and things like that, that's a red flag, because what medical examiners are supposed to do is stick to science. They're not an arm of law enforcement. They work with law enforcement closely, but medical examiners look at, they perform an autopsy. They look at somebody like Mr. O'Keefe and they say, the cause of death here probably is hypothermia, which is understandable. And he was unconscious from some traumatic injury before, da, 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 da. Now, the reason that they may have said, we can't tell you the manner of death, is because they don't know how those injuries got there. Maybe he fell, maybe he slipped. Don't underestimate the significance of this coming out on cross. And, again, they couldn't even, all homicide is, by the way, homicide is a legal term of art. Homicide can be murder. It can be justifiable. All it is that person A caused the death of person B. It's not an editorial word. And a manner of death could be homicide, suicide, accident, things like that. And they didn't even call it a homicide. But what they did say was, this is not from a fight. That's not medical. That's law enforcement talking to them and either asking them to say it or pushing a narrative and whatnot. And, again, the autopsy takes a couple days. There's plenty of time at that point for people to get in the ear and ask the ME, the medical examiner, what is this? What is that? Can you tell me that? Or can you put this in the report? And that's a non-scientific thing. And all of this stuff is, add in the dog, the dog that got rehomed. I understand. Bit someone else.
Yeah.
Listen, if I'm the defense, I'm trying to get all that in. There's just question after question after question. And you haven't even gotten to one of the other real problems the DA has here, is that in order for Karen Reed to be convicted, you have to find the people in the house credible about a number of things. Now, that's going to be difficult for a lot of reasons, because, again, what a skilled defense attorney, which these three of them are going to say, this whole idea with the deleted call records and things of that nature. And, you look at McCabe, I think her name is, you say she's presumably an innocent person in all of this. Her friend was found dead and might have been killed by someone. So you think, and jurors do this, they think of normal, reasonable situations and how a normal, non-suspicious person should act. Okay. I can assure you that how a normal, non-suspicious person acts is not by deleting, and sanitizing their cell phone and text messages with the guy who died and the other people involved in whatever the hell happened that night.
Right. And deleting their contacts,
This is
deleting them out of
crazy.
your phone completely.
Right.
Like you don't know them now.
And the defense is going to say, because the DA is probably going to try to introduce Karen Reed's phone records, who is acting suspicious here? Karen Reed,
Exactly.
who did not delete anything, didn't do anything like that, or this woman who was at the house who's deleting this, searching about the stuff, how to die in the cold, how long does it take? And I understand that they're going to argue, oh, that's from 6:30. This is another problem the DA has. They have the burden of proof. The bottom line is the defense is going to have an expert, a credible expert, not the Wendy Murphy type who says, there are whores who will say anything. Again,
PhDs.
right.
No.
Again, Wendy says the jurors, everyone knows that, defense will hire experts who will say anything. Again, let's put Wendy at the little kids table and leave her out of this. A juror is going to assess the credibility of a defense expert and decide for themselves by what the expert's credentials are and what they say about why we think and know that this happened at 2:30. Now, the DA will offer their own theory. The problem is if the jury says, well, I don't know, that doesn't work for the DA. They have the burden of proof. And if you have the burden of proof and you're the party that's speculating what could be or maybe, you're done. You can't do
Right.
that. So, these are all those kinds of things that are just, where are they going? Because again, Chief Wiggum found a taillight.
Chief Wiggum. I love that. Let's play some more of this. I want to hear Eliza Little. We're going to go back to her and watch this defense come back about Proctor and Michael Lank.
You can, but I'm more focused on the bias or motive.
I'll
part.
just briefly address Graham and McFarland because
Sure.
I do think it's very important that we make clear that both of those cases are completely an opposite to the issue that's before this court, which is admissibility at trial. McFarland and Graham both deal with whether the Commonwealth has an obligation to turn over certain discovery. That's not where we are right now, right? We filed the appropriate motion to receive discovery. We obtained information about an IA investigation. We obviously
Let's focus on Lank first.
Sure.
Okay,
So-
I agree with you. They're discovery cases. They're not
Interrupting all the
admissibility
time.
cases.
So that issue aside, Lank has he's one of the first responders, obviously, who went to 34 Fairview on the morning of January 29th. He's the first person to enter the Albert residence that morning. And he has a long-standing relationship with the Albert family, which is brought in by this sort of prior lawsuit that we brought to the court's
The
attention.
Albert family appears to be
And I'm
huge, right?
well,
Or very extended family.
well, I'm getting there. So
Okay.
the altercation that Lank was involved in was after he deputized himself to involve himself in a fight that Chris Albert had been in. Chris Albert is one of the Commonwealth's witnesses in this case. He is Brian Albert's brother. He was with them all that night on the 28th. His son, Colin Albert, as you know, is a third-party culprit. So this is not some tangential family member. This is
Who would you intend to get, if I allow this, and we really need to see how things develop beforehand. So, Mr. Yannetti, I can tell you right now, I'm not going to allow you to open on this because I need to see how the evidence comes in.
It's not part of my opening.
Okay. Who would you intend? I see you have the Lopolito brothers on the witness list. I think that goes far further than I would allow. But who do you intend to get the testimony in through and how?
through Sergeant Lank himself. I think we
Okay.
need to be afforded the ability to cross-examine him. Once that's done, we may need the local
If he
law
denies
to-
it, and we'll
Exactly.
figure that out.
But I think the first step is allowing us to inquire as to his relationships and the connection that he has to the family and this incident that occurred.
So you can certainly inquire as to his relationship with the family. It's the incident. I need to see again, just reading of everything that I've read, Sergeant Lank doesn't have his testimony isn't as lengthy as other witnesses, right?
I don't think that that's necessarily true, Your Honor, as far as our
Mr. Lally said,
cross-examination.
okay, but for his direct is not as lengthy as other witnesses.
I think that's fair to say.
Yeah. So, all right. So go ahead. So through him, through Chris Albert.
Through him, potentially through Chris Albert as well, Your Honor.
Okay. All right. So, Mr. Yannetti's not going to open on this, and he said he wasn't planning on it anyway. So
No, Your Honor.
let's see how the evidence develops. It may be that we have a voir dire of Sergeant Lank and Chris Albert beforehand. Okay. So, I'm not going to take any action on this right now.
Okay.
But I'm not denying it as the Commonwealth's requesting me to do.
Thank you, Your
So
Honor.
we'll see where we go with this. Okay. All right. So now let's deal with the Trooper Proctor part.
What did you think about that, Attorney Bederow?
You know, I don't think it's as bad as a lot of people think. Number one, in terms of, again, her judicial demeanor, and maybe I'm desensitized because I practice in New York City, where it's a judicial right to interrupt, any conversation at any time, and it happens all the time. And maybe I'm just desensitized to this, but it is not uncommon for judges to interrupt and focus the discussion to the issues that they feel are necessary to decide the issue. Her ruling makes sense. Again, so however you view her demeanor, I think what she said was, let me hear what the evidence is, and we'll go from there. I don't think this is so awful. I don't.
Do you ever experience a judge in your legal experience that interrupts you as much as Auntie Bev has interrupted David Dunetti and Alan Jackson and Elizabeth Little?
A hell of a lot worse than that. Yes.
Oh, wow. Okay.
Yeah. I again, maybe I'm just desensitized to this.
Yeah.
I don't think a judge interrupting is, it's just the kind of thing that happens every day, because at the end of the day, they want the information that they think they need is required to make a decision. Okay. And if you're addressing someone else, they're not going to just sit there and listen and daydream and then say, when you get to it, I'll pay attention. I wouldn't read into this. And also I would caution people, a trial is a long, long process. There are going to be skirmishes, battles, and ultimately you want to win the war. You're not going to win every skirmish. You're not going to win every battle. There's going to be things that go your way, things that don't, but you have to keep your eye on the ball, eye on the prize. And ultimately, whether they're going to, be able to examine Sergeant Lank for something that he was alleged to have done, but there was no finding of wrongdoing 20 years ago, is not the kind of thing that's going to flip the case. Now, if the allegation is the first cop who responded knows the Alberts, then I agree with what everyone else was saying. And I think they were saying in the courtroom, you're going to be allowed to get into that relationship. You have to. Now, it may turn out that, I was there for 5 minutes, I didn't do anything, and I left. And then the defense has to make a decision. Do you want to get into this? Again, credibility. You don't want to be, even when you're alleging a conspiracy or a cover-up or incompetence, you don't want to be a Chicken Little, okay? Everyone's part of it. Everyone, the judge, every cop. Not every cop is bad, even in a frame-up case, okay? So I think if I'm them, I'm really focused on the larger picture, the proctors.
Follow-up question for you was, I wanted to ask you, so you said that it's common for judges to interrupt you as a defense attorney. Now, do you see in your experience that you as a defense attorney often are interrupted by the judge more than the prosecutor?
Of course.
Okay. Okay.
Look, courtrooms are anyone who's a defendant, and by defendant, I mean lawyer, client, or whatever. You don't want to be there. You're being brought there by legal process from the prosecution, under the power of the court. And there's always this feeling of inequity to some extent.
Yeah.
But, I just would not read into it. I wouldn't worry about it. I mean, look, if she's telling you, I'm not going to allow you to introduce any evidence, an accident reconstruction or something. I'm not going to allow you to do something like that. I'd be concerned. By the way, that's another thing I should have mentioned earlier about why they have a reasonable doubt problem is 3 accident reconstruction witnesses who are going to say, in our expert opinion, that Mr. O'Keefe's injuries are not consistent with this. And, I know they're not going to be able to say that you were hired by the feds. We're getting into areas that are off limits. But what is definitely going to be elicited from those witnesses is, are you frequently called by the government to look into? In other words, they're the good guys, right? These are not the people that Wendy Murphy claims can be hired to say anything, and jurors won't be fooled. Once again, she's showing her complete lack
Absolutely.
of how a trial works and common sense. But I wouldn't worry about the judge. I really wouldn't.
Awesome. Okay. All good points. Let's go back to the watch Liza Little. I want to see more of this. Lally.
Trooper Proctor, Your Honor, in regard to any IA investigation, which we have not received any material in regard to other than its existence. And I want to be clear on that because I think counsel might be a little confused by some material that we provided to them. So there were some interviews in regard to any sort of areas of potential bias with regard to Trooper Proctor and certain members of the Albert family. That was something that we did. So we had asked a couple of captains from the state police who are completely divorced from the investigation and completely divorced from our office, conducting interviews with regard to Trooper Proctor and a few of the other civilian witnesses.
Okay. How recently? I mean, it's all recent. When was that?
That was, I think, all discovery related to that was provided to counsel the week prior to trial.
Okay.
But they were done sort of in the weeks leading up to that.
Is that part complete?
Yes.
Okay.
So as far as the IA investigation goes, just the mere fact that there is an IA investigation, the Commonwealth would submit is not an appropriate area for cross-examination, and particularly when it's an open investigation, there are no findings and falls squarely within McFarland and Graham. And I understand what the court's comments before about them being primarily discovery cases, and I would agree with that. But they also go to discovery cases as far as so if something can't be ordered to be provided in the course of discovery, then it's I would submit inferentially inadmissible. So what I'm suggesting with this motion, what I'm arguing in this motion, is that whereas there is no findings of liability, there's no findings of any wrongdoing or anything of that ilk, just sort of putting out there that there's an open IA investigation without anything more, because nothing else exists at this point.
Why wouldn't it go to his bias and his motive? If he's under investigation, why wouldn't he have the motive to testify favorably, or why doesn't it go to that? Maybe not the fact that it's IAD, but just there's an ongoing investigation that he's aware of, that he's involved. And I don't know if his job depends on it. I don't know that. Maybe there's not enough to know. But why isn't that motive and bias on his part? Do you think that's prohibited by Graham and McFarland?
I do, and just for that specific, because essentially what it allows a defendant to do is to pursue a line of questioning that they have no idea what that line of questioning is or what it will eventually be, and it could eventually turn into nothing, and to allow that sort of imprimatur of the court to allow that sort of questioning into an area that is completely unsettled and completely there's no evidence to substantiate other than the fact that it exists, without any sort of finding, without any sort of evidence to support it. I mean, we don't have any evidence as far as what that is or that it even pertains to this case. So with regard to all of that, I understand, that outside of McFarland and outside of Graham, that there are other avenues, as the court was alluding to, as far as motive, as far as bias, as far as things of that.
It's really painful listening to him after a while, isn't it?
Oh, it's horrible.
Yeah. And again, I just want to go back and say, listen to the questions the judge is asking. Those are the right questions. It's the right analysis. And if one of the things I think what Lally said, it is hard to kind of digest it all and turn it into cogent thought and analysis. But I think what he was basically saying was, well, there's been no determination and we don't even know what's going to happen. So to allow them to do it now would not be fair. But if he's also tacitly acknowledging that if there were a finding, okay, that it could be relevant, then that's giving the state, Commonwealth in this case, incentive to drag it out without a finding to prevent them from using it. Look, this is all ridiculous, okay? Proctor is going to get clobbered up there with his bias, with all of it, okay? And the fact that he was under investigation because of the things and relationships that he had, whether he didn't disclose things, whether he even testified falsely in another, a federal investigation or whatever, his bias and motive is a centerpiece of the defense here. I mean, I know I'm repeating myself, but it just has to be said. A critical claim that they're making is that this guy is dirty. And you may believe it or not believe it, but there is evidence that at least could support that argument.
Exactly.
And it also would tend to show, even if he's not dirty, that he was biased and it steered his incompetence. In other words, because I was friendly with these people, I didn't want to look. I didn't want to know. And it's not that I'm necessarily going to frame it on this poor woman who happened to drive him and leave, but I didn't really want to pick the scab of who these people were. So, and if he did that and didn't search the house, didn't look carefully, didn't record interviews, didn't do this, or things that he should have done, and the reason for that is because he's friendly with them and then lied about it.
Yeah.
Okay? And then lied about it under oath.
Yep.
And which led to an investigation. This prosecutor is out of his mind, okay, if he thinks that a jury should not hear that this cop, according to the defense, is either dirty, incompetent, or God forbid, both.
Right. Probably both. It seems like both. His cover-up was incompetent. It seems like, yeah, I mean, this is just going to be amazing. Tomorrow it starts 10 a.m. We'll all be watching. I do want to play a little more video. We've been over 90 minutes now. So do either one of you have to leave? We only have like maybe 10, 15 more minutes of video left. Yeah. You want to play?
I got like a 9 p.m.
my
cutoff.
bedtime yet.
Yeah. You can stay up late tonight?
Yeah, I've got my own messy hearing I have to deal with tomorrow. But yeah, no, go ahead.
All right, cool. Yeah, I got a long day tomorrow too, but we'll definitely be done by 9. Let's just say that.
Perfect.
Let me bring this video back up.
Nature, but when it's just so scant as far as what that is versus sort of the connotation behind those questions. I just think it's unfair to the Commonwealth. It's unfair to the witness to be put in that position when there's really no information available.
All right. What do you say, Ms. Little?
Your Honor, I think that ADA Lally's representation that we don't know what this investigation is about is disingenuous, to say the least.
Why so? Why? Is there
Reason
something in
is-
the, hold on, is it something in the information that you've received
Yes, Your Honor.
from
And-
Mr. Lally?
Yes, Your Honor.
All right. So can I get a copy of that?
Yes, Ron.
Okay.
So, as the court knows, first of all, Grimm and McFarland deal with the Commonwealth's mandatory discovery obligations, right? Those courts also very specifically state that there's mechanisms outside of those mandatory discovery obligations for defendants to obtain information that's relevant and admissible at trial. That's why we filed a Rule 17 motion requesting these disciplinary records, and that's why that was granted.
It was granted because the Commonwealth did not object.
So regardless, we've obtained those records, and the cases that Mr. Lally continues to cite do not stand for the proposition that that's the only mechanism by which information can be produced at trial. Those are discovery cases. They are not admissibility cases. Pursuant to that request, we have received information discussing the IA investigation at which Trooper Proctor is being questioned specifically about this case. This is not an instance where we're questioning whether or not there's a basis for an IA investigation. It's clear this investigation was predicated on the materials that were produced to the Commonwealth by the federal authorities in this case.
And initiated by the Commonwealth. The IID investigation was initiated by the DA's office, correct?
Well, as far, and just to correct what I certainly didn't mean to impute that this case had absolutely no bearing, or there was no
I
basis for
didn't
that.
think you did.
But what I was saying,
That was not a good moment for him, was it?
No,
No.
lunchbox.
Yeah.
with that is we don't know what the full extent
Want
of
to get
that
away?
is. But
Grab
as
a
far
Snickers.
as
Yeah.
what counsel is, what the court's question as
Oh,
far as the
no.
IED, it was something that our office had spoken to. We felt we had a duty to disclose to State Police Legal Counsel, and then they refer it to the IA, and that's how that investigation began. As it pertains to what counsel is talking about, that has nothing to do with IA. So the materials that the Commonwealth has provided, that was completely separate investigation initiated by the District Attorney's Office in
Okay.
relation to that.
Okay.
The IA investigation came on the heels of this information being produced to the Commonwealth. This is not a situation in which we're really questioning what the basis of that investigation is. The Commonwealth has in its possession numerous materials that suggest there has been significant misconduct on the part of Trooper Proctor. That will come out at trial.
How?
However,
How?
through cross-examination.
What if they don't call Trooper Proctor
We will call Trooper Proctor.
to impeach him?
Yes.
All right, so be prepared to argue that.
That was amazing, wasn't it?
Yeah. Oh my goodness.
Look, this gets a little like legal nuancy and wacky, but if they don't call Proctor, obviously that is such a red flag, and the DA at that point should just put his, put his papers in his briefcase and just leave and go home and let's not do this. And then the defense says, we'll call him. However, when you call a witness, you can't call a witness literally for the purpose of impeaching them like initially. So it gets a little trickier than that. I still think there's a way to do it and it would come out. But the idea that they would not call the lead investigator who interviewed these people is ridiculous. It becomes even more ridiculous because of how pathetic his investigation was. And we go back to what we talked about an hour ago. He took no notes. He did nothing. How else? What if there are reasons to believe that these witnesses said different things? The witness who you would say, didn't they tell you this, would be Proctor. And you would still want to get out that there were no notes. This guy is testifying. That's no chance he's not testifying.
Amazing.
Yeah, no, it's they look very nervous and flailing from the prosecution side, very defensive.
Not confident, that's for sure.
No, they don't. And it's, this case has been going on for whatever it is, 2 years. These issues are not new, and they just seem very hyper defensive about things that are so obviously going to be issues. And I'm just literally, the idea that they could, with a straight face, ever suggest that we're not calling the lead investigator on this case, who, oh, by the way, is a personal friend of the people we think are involved, the civilian witnesses, in some sort of cover up, and he's friends with them, and he didn't do things that he would have done. This is a shit show. Pardon the French.
Yeah, no, you're right. 100% accurate. That's exactly right. I mean, not only should he be called, he's the absolute person of maybe the top 3 people that should be called without question. It's come on.
Amazing.
He's going to be confronted about a lot of unpleasant things, and he's not going to have any good answer. And by the way, the good answer is not going to be, well, I know them, but I might have said I didn't, and this and that, and I didn't take notes because it's not our practice to take notes. That's just not going to do it. And it's not just him. To go back to some of these things, because again, you never look at this evidence in isolation. At the end of the trial, the defense is going to marshal this. They're going to do this as part of their overall theory of the corruption angle of the case. Is they did nothing. I mean, whether it's Proctor, whether it's anyone else, how are they going to explain with a straight face that they never went in and searched the house where he was? And at any time, I mean, or go, I know there's this issue with, O'Keefe's Apple Watch, for example, which circumstantially would seem to suggest if he's going up and down and
Correct.
moving around, he had to be in the house. I think that's a pretty
Yep.
safe argument, again, notwithstanding the Wendy World argument from the other day that, well, his phone was moving after he died. So
Yeah.
how reliable is that? And
Yeah. When the state police showed up and picked it up. I mean, come on.
yeah, Wendy, phones don't literally, self-combust when their owner dies and therefore shut down. So, how do you not at any point do that? How do you not conduct all these interviews? How do you explain the lack of missing video? And I know I'm repeating myself, but these are points that the defense is going to hammer in throughout the case over and over. And then the jury is going to be instructed, at the end of the case about what reasonable doubt is. And reasonable doubt is a very high standard. I mean, if there is any reasonable basis to believe that she didn't do it, you could think she did it. I'm not suggesting she did. You could literally go in the jury room and say, you know what, as we're sitting there with 12 of us, I think she did it, and they all think she did it, but there are a few loopholes which maybe she didn't. That's not guilty. Even if they all were to come out and say she probably did it, probably is not enough. And the question becomes, what is the evidence that she did? Never mind reasonable doubt, because again, we found a missing taillight. I know she made a statement at some point about, oh my God, did I hit him? Did I hit him? Or
I don't know. He's on the witness list. He's the first person on the witness list.
Sorry.
None of that is going to carry the ball. The medical evidence isn't going to do it. There's no witnesses who saw this. There's no anything really that is going to demonstrate beyond a reasonable doubt that she had to have done this.
Excellent.
That I can see.
Yeah. I think there's so much it's like driving a truck. It's just, there's so much to this. They're going to be able to do the doubt.
There's an ocean of reasonable doubt here. I've been doing this 25 years, both as a prosecutor,
probably calling him,
and as a defense attorney. Lawyers who do this for a living, we think about this stuff all the day, every day, in any number of cases. And this is one of the ones where if you told me today, this is all the evidence we have, should we even seek an indictment? I would say no. I mean, never mind the higher standard. I would say there are too many loopholes, too many questions that have not been answered. What are you going to indict her on? The chief who found the taillight and the people in the house who say he never came in here. He never came in here. And I mean, what makes them believable? Because there's 5 of them, but they've all got the same issues and problems. It's not compelling at all.
Just
he's the lead
hypothetically
detective in this case. He's conducted every single step of this investigation.
With others, right?
Excuse me?
With others?
Sometimes, but he is the primary investigator in this case. And I think it's very, very important for the court, and I think you noted correctly, that bias and motive are absolutely critical to Ms. Reed's right to defend herself at trial. We have to be able to explore those issues. And in order for Trooper Proctor to testify, he has a motivation to testify in a certain way to avoid liability in this pending IA investigation. So I think it's unfair to tie our hands behind our back and not be able to question him about this, because it directly drives his bias and motive in this case and gives him reason to testify in a certain way, knowing that he could face career consequences if he doesn't.
That's it. That's the point.
Do you intend to try and open on this, Ms. Gianetti? Because I need more information.
I'm not going to mention the IA investigation in my statement.
All right. So, Mr. Lally, if you can get me that information that you mentioned that you had sent to counsel, I'll take a look at that. It may well be the fact that there's an investigation without what the nature of the investigation is, but that there's an important investigation. And if you can show me in advance that his job may depend on it, things of that nature, there may be cleaner ways to allow this testimony in. So All right, so we need a
Get some
little
sleep
time. I
on
need
it,
to
Bev,
read
would
those
you?
materials.
That's the proper ruling. I mean, you don't have to call it an internal affairs investigation, but I mean, the lawyer on behalf of Karen hit the nail on the head. I mean, he could be entirely motivated to testify in a way to save his own ass in a number of ways, as well as just protect the prosecution's case and my relationship with them. And the jury has a right to know that. And, one of the things we talked about this earlier too, the right to impeach a witness based upon bias is a fundamental right to confrontation. It's a famous case. Anyone who does this it's Davis versus Alaska, the U.S. Supreme Court from 1974, which stands for the principle that, a witness's motive to fabricate is always relevant in the case. Okay. And if there is evidence of that, and it is a constitutional right, okay, it trumps the DA's concern. Well, maybe he'll be found not responsible for IAB, or maybe we don't have enough information. What I thought about when he was saying that, not that I would ever say this in court, but was Clint Eastwood and, being all broken up about that man's rights. Please, it doesn't work that way. Okay, Karen Reed is on trial for her life. Her constitutional rights and her right to a fair trial trump everything. Okay. The centerpiece of their case is that this is a dirty case, and this guy is the architect of the dirty process. He's potentially in employment trouble, legal trouble. He's friends with these people. We have every single right to attack him for every reason he has to be biased in favor of the DA and against me. It's coming in. I mean, and if it doesn't come in, and God forbid she gets convicted, guess what's going to happen? There's going to be a do-over, because an appellate court would toss it, assuming it's material. And I don't know how it couldn't be that the lead investigator, had actual or potential modus or bias for which there was a lot of evidence.
Correct.
In which the judge decided, well, I'm not going to let that in because the DA says, well, we don't know the results of his IAB investigation. And I think the judge handled it well. Let's not call it an IAB investigation. There's an investigation that he has an interest in. That works. That's fine. I think you're silenced. Can't hear you.
Your audio's still off, Mike.
Sorry, I always do that lately. Sorry. I'm too comfortable.
Mark's words are leaving you speechless, Mike. That's what's happening here. He's just saying everything perfectly tonight.
Yeah, exactly. You get the words right out of my mouth. But I'm so thankful that we've been able to have you on, Attorney Bederow. The audience is really excited that you're here. Will you be able to join us throughout this trial as it goes on? Yeah.
As I told you the other day, the only when there are Celtics and Bruins games, not
Celtics and Bruins games.
Both won last night.
That was
what's going on? What's the series? Is it
2-1 Celtics, 3-1 Bruins? We're good. We're good
on both.
We're good on both. But yeah, no, I'm happy to join and talk to people about this, and it's good there. There aren't enough forums here that are doing this. I think having a reasonable discussion about this. I mean, the online stuff that I'm seeing is just, I mean, it's like a lunatic asylum, and it's just crazy town. I didn't expect that in Massachusetts, to be honest with you. We deal with this kind of stuff all the time, and I'll tell you something. If this was going on in New York City with the media stuff, because this is getting coverage here, just so you know as well. It has
everywhere.
Been New York Post, it has been national. But if they were living this day to day, and they saw the kind of crap that the DA is bringing to the table, and the apparent weaknesses, and the stuff going on with the witnesses and the sideshow act with the Wendy's and all of this, they would be having a field day with that. Of course, as you know, they're preoccupied with Trump right now over here. But it's great that you're bringing attention to this and that other people are. And the key is jury selection. If they picked a jury of reasonable people, there is no way that there is reasonable doubt. And again, you can think all you want. Well, I don't like the fact that even if you buy the taillight story, or you're concerned about the statement that she made about, oh my God, I hit him, or whatever, that's not enough. There are so many things here which just don't make sense, and that you wouldn't. I mean, this case is so crazy. When I read for the first time that shortly after this happened, they sold the house. They fixed the floor. They
got rid of the dog.
They got rid of the dog.
They got lawyers. So many
Well,
things.
I never fault.
I don't. In a way,
I'm
I
never
don't
going to
blame
fault
them.
anyone, even innocent people.
I get it.
Getting lawyers.
I had to get a lawyer over the shit lately.
There you go.
There you go.
But,
and I didn't do anything wrong either. So I hear you on that one 100%.
It's just,
but so many weird things that they did do. I want to thank you so much, Attorney Bederow. Mark Bederow. It's Bederow Law on X and your website.
Yeah.
People can find you. You're a New York-based lawyer. Do you just cover like criminal defense in New York, or are there other states that you've admitted to the bar?
New York. I'm admitted in New Jersey too. I dabble in New Jersey, and I practice in federal court in New York as well. And I've been in some other cases in some other federal districts, but yeah, mostly New York.
Awesome. And Mazza Media.
Thank you, Mike. Great coming here again. Looking forward to this week. Ready to get this trial underway.
Awesome. And you do both. I guess I'll give you both final thoughts tonight, because we do have like 5 more minutes here. What are your final thoughts first, Mazza Media, and then we'll go to Attorney Bederow?
Yeah, I think it's going to end with Karen Reed not guilty. I think that's how it's going to end up going. I think that there's too much reasonable doubt here at hand. And at the end of the day, there's just way too much in her favor. And I think, like I've said in another post I posted a few weeks ago, was that when you just look at John O'Keefe, if you get a medical examiner on the stand, and Mark talked about this earlier, and they go up there and they say that the injuries on his body are inconsistent with someone who got hit by a vehicle in reverse. To me, that one aspect of it alone is enough, in my opinion, to win a jury over, to raise an eyebrow and say to themselves, this is not a woman that did this, and there's just not enough evidence to prove it. And I think it's going to be a dominant performance by the defense throughout this course of this entire trial, beginning tomorrow. And I'm very much looking forward to the opening statements from Karen's defense team. And those are my final thoughts.
Thank you so much, Mazza Media. And the Attorney Bederow.
Trials are long in something like this. They're stressful, and for the defendant more than anyone else, the families, the lawyers, but even in a case like this where there's so much public interest and support, and I would simply caution people to take a deep breath. It is a long process, and not judge, am I winning, losing after everything that happens. You're going to hear things that if you believe she's not guilty, you're not going to want to hear in the opening statement. That's going to be the DA's best way to present what there is. Witnesses may very well lie, as unfortunately they do. But I would say you just have to keep your eye on the ball, wait till the evidence comes in, hear the arguments. And if you saw what the definition of reasonable doubt is, and by that, I mean what the judge is going to tell the jury, I think you would be very comfortable in feeling that the strong likelihood here is that she's not going to be found guilty. She is in the hands of very accomplished lawyers. There's just by watching the video. I'm sorry, I missed her name again. Was it Miss Little? Nice job. Good argument. The other two guys obviously have been doing spectacular job. The DA seems to be flailing. They don't seem confident, and I get it. They're not confident because they don't really have much, but you just have to get through it. And I think you'll all be happy when this is over. And then the last thought that I would say is that, a man did die here, who, was a respected police officer, as I understand it, was taking care of 2 young kids for other tragedies that had happened in his family. And I think it is important to recognize that it's not a game. It's not a blood sport. I mean, the defendant is traumatized. Her family is traumatized, but so is the family of, Mr. O'Keefe. And you see this a lot. I see this a lot in a lot of cases, that people who are murder victims, their family and friends, they can, I'm not saying it's always the case, they can get irrational because they're angry, they're pissed, their loved one is dead, and the DA is telling them she did it. Okay. And they gin them up. And so I just would suggest also to, have respect for his family and tune out the nonsense that's going on and just focus on what happens in the courtroom. And I think Karen Reed will walk out a very happy person.
Me too. Thank you so much, Attorney Mark Bederow, and Mazza Media for being here tonight.
Thank you.
Oh, great.
Have a great night.
Thank you, Mark.
Thanks, guys.
And I'm going to just read a bunch of donations and support that came in tonight. I want to thank you so much for supporting us. It's been pretty amazing. And I also have them on the screen, the Reed family, because I think that they've been attacked a lot too. So I want to, support Melanie Little, support the Reed family, support John O'Keefe's family too. I know that they're on two different sides at this point, but I think at the end they're going to be united. I really feel like that. It's going to be crazy tomorrow, 10 a.m. I know a lot of you are questioning whether this is actually going to happen. I think it's going to happen, but you never know. You never know. All right, I just want to read some of the donations that came in tonight. Saw quite a few of them. Peter sent $15. He says, Lally size 25 cents per exhale tonight. Carolyn Cap, she sent $10. She said, keep up the great reporting guest, Mike. Indie Journos, where it's at. Thank you so much, Carolyn. Thank you so much, Peter. Suzanne sent 35. She said, thanks for the informative stream. Hope that you had a great birthday. I did absolutely have a great birthday. Caroline on the Cash App just sent some money too. Hoping I didn't lose. Did I? Okay, hold on one second here. Okay, so that's on Venmo. Let me just check the Cash App. I did see some come in there too. Yes, Caroline Fourth. She sent $10. She says, for reporting the truth as always. Thank you so much, Caroline. And late last night, Lisa C sent $10. She said, love your show. Happy birthday, Mike. And we also had some super chat money come in tonight. I want to make sure I recognize all them. A bunch of them. Let's go back to the most recent. Latina sent $19.99. She says, Mark Bederow is amazing. He should have been on way sooner. Well-spoken. Of course, he's a New Yorker like myself. I'm on the same side. Can't stand Wendy. Wendy said in September, Karen Reed was firing her attorneys. I know. How many times has Wendy and Kevin and all those jokers been wrong? Over and over again. They said she was going to take a plea. Suzanne threw $5 on the super chat. She says, Mark, they only say that they never saw him enter the house. No one has said that they never saw him in the house. Good point. Luna's mom, 24, gifted 5 Young Jerks memberships. Thank you so much. That's 5 new people who get to be members. Thank you so much, Luna's mom. Thank you for watching, commenting, and donating. Cynthia Lynch, $4.99. She says, great show, Mike. Free Karen Reed. We also had some new members sign up. Sarah O tonight became a new YouTube member. Mark Randazza, the attorney, became a new YouTube member. Awesome. And DW 1999, he said, great show, Mike. Thanks. I think I'm missing another one. Here's another one that came in. John Barron. We already read that one off. Thank you so much, John. Thank you, Mark. Thank you, DW. Thank you, Sarah O, Cynthia Lynch, Luna's mom, Suzanne and Latina for all the YouTube super chats. I want to thank everyone for watching, the guests especially tonight. We started off, it's so funny, like I know if it's a good show if the numbers go up. We started off like 200, 300, 400, 500, 600, and then we were up to over 700 people. I saw at one point like 750, 760, 770, almost 800 tonight. Actually, 773 was the latest I saw. That was on YouTube alone. Right now, we still have over 600 people on YouTube just listening to me, and a lot of people on Twitter and a lot of people on Facebook and even Twitch tonight. We even had people on Twitch tonight listening, which never happens. So pretty wild. I want to thank everyone. I think that we're probably over 8,000 subscribers now on YouTube. It seems like just less than a month ago, we crossed over to 7,000. We're now at 8,000, I believe, after tonight. Our Twitter's going crazy. Our Facebook. It's really exciting to see. I want to thank everyone for supporting our coverage. If you haven't done so, about half the people who listen and watch the show don't subscribe on YouTube. So please hit the subscribe button if you haven't subscribed yet. Make sure you're getting the notifications. Tomorrow morning, 10 a.m., we'll be live broadcasting the Karen Reed trial, the opening statements. Hopefully it starts right at 10 a.m. We'll be broadcasting streaming. Also tomorrow at 7 p.m., we'll be live from Canton, the police audit committee meeting, first one, publicly going to be streamed, public meeting. We're expecting some fireworks at this thing. We'll be broadcasting that at 7 p.m. On Tuesday night, there's going to be the Canton Select Board. We'll also be broadcasting that. So please check our YouTube, hit the notification, get reminded. We got a bunch of events coming up. 7 p.m. every night, be here. As well as during the day for the Karen Reed hearing. We got a lot more shows planned, and hopefully, I think we're going to get some more attorneys on here too. And agreed, Ani Bev is always late. We know that. I bet. I just have a feeling there'll be some last minute delays, and we may not hear the opening statements until a little later. We'll see. Hopefully, it starts right at 10. We'll see. Thank you, everybody who's been supporting, following, streaming. I want to thank all the other creators out there, the people on X and Twitter too. You guys provide so much information, screen captures you send us, the tips, the info, and obviously the financial contributions too. I really appreciate those. I want to thank everyone. Stay strong. Stick up for each other. Don't let them give Melanie Little any shit. Don't let them give the Reed family any crap. We'll see you tomorrow, everyone. Have a great night. Thank you so much.